This introductory gathering is meant as a contextualization of a source that I have been transcribing now since I think the spring of 2020. It's trouvaille, something that you stumble upon when accidentally going through archival inventories. And in this case, the inventory in question for me is number BA 05100047002849 FRE, Inventaire des papiers Arendt, the French-speaking inventory of papers found in the Belgian State Archives, deposited by the widow of the late Léon, Léon as he signed himself, and he was mostly called Arendt, who was Director General, a most senior position at the Belgian Ministry of Foreign Affairs under Leopold II. And this description triggered me because at that time I was working on Belgian neutrality. See here, 1, Histoire du Congo belge, fondation, exploitation, reprise, etc. 2, la question militaire. 3, la politique étrangère de la Belgique, surtout la question de la neutralité. And as we often see, this kind of inventories is neither complete nor reliable, because the pièce maîtresse, the most beautiful piece of the whole fund, is this, a handwritten course on the law of nations, unpublished, probably without the author ever having had the ambition to do such a thing, on le droit des gens, the law of nations, what we would call today international law. This is especially fascinating because Léon Arendt is the author of countless memoranda, countless notes and advisory preparatory pieces for the minister and Belgian diplomats in a peculiar epoch, which we used to call the Belle Époque, or the fin de siècle, the transition from the 19th to the 20th century, which coincides in Belgium with the reign of Leopold II and the acquisition of the Congo Free State by Leopold in a personal union between Belgium and Congo. This is, of course, not the only side of the story. As we will see, Belgium, as a permanently neutralized country, had a specific attention for its security. It hoped to achieve that security through the codification of international law and the institutionalization of a system that was largely inherited from the early modern period and the system of the Congress of Vienna. I will proceed in 2 steps. First, something on the man and the document. Next, something on the treatise on the law of nations, so on the contents of what Arendt tried to convey in this course himself. On this slide, while I'll gently close the door, on this slide we see a summary of the common narrative on Belgian diplomacy at the end of the 19th and the early 20th century. In 1839, when with the Treaty of London, Belgium was internationally recognized as an independent state, and its independence was guaranteed in exchange of the obligation of permanent neutrality. Since that point, Belgian diplomacy worked slowly towards emancipation and consolidation of the country's status on the international scene. An important step is summarized on the right, and on the right you see a commemorative stele, a beautiful work of art, imaginary, to commemorate Baron Lambermont. Lambermont was one of the main diplomatic advisors of Leopold II in the Ministry of Foreign Affairs. On the stele you see traité de commerce, affranchissement de l'ESCO, codification des lois et usage de la guerre, traité de Berlin, fondation de l'État indépendant du Congo, arbitrages internationaux. This image tries to convey a straight line from the conclusion of treaties of commerce, which were seen as a way to exploit the advantage of permanent neutrality, namely that you can trade with everybody the whole time, to the next step, the end of the compulsory toll on Skelt, which controls the access to the port of Antwerp. An important moment where history tries or seems to go faster is the foundation of the Institut de droit international, the Institute of International Law, Justitia et Pace, of which you see the logo on this slide. At this moment has been studied by scholars such as the Belgian Vincent Genin in his book Le Laboratoire belge du droit international, une communauté épistémique et internationale de juristes, where Genin, as an intellectual historian, tries to make a collective biography of the Belgian lawyers who shaped the institutionalization of international law in the second half of the 19th century. The path for a more profound study by lawyers of this moment was, of course, Kosciuszko's book, The Gentle Civilizer of Nations, The Rise and Fall of International Law, 1870-1960. The Institut is classically seen as a start of a period where international gatherings make statements of principle, like the Declaration of Brussels of 1874, which contained a blueprint or a first version of what will become the first codified jus in bello, or the rules on how war is waged, the precursor of what we call today international humanitarian law. Curiously enough, the image celebrating Lambermont also highlights the Congo Free State in 1885. The Congo Free State is the result of the personal ambition of Leopold II, King of the Belgians, to establish a colony, an ambition that the Belgian monarchy has had since earlier on in the 19th century. The recognition of a series of treaties of cession concluded by local rulers with Leopold's people in the International Congo Association is seen today as the precursor and the immediate preparation of a system of ruthless exploitation. A recent book of Andrew Fitzmaurice on Travers Swiss, British lawyer who helped to legitimize Leopold's plans in the Congo Free State, is an intellectual exercise in that direction. Travers Swiss looks for the intellectual foundations of Fitzmaurice looks to the intellectual foundations of Travers Swiss theory of international legal personality, where, of course, the creation of a bizarre state as the Congo Free State in 1885 takes a major place. The course notes of Arendt are written by his students or jotted down by his students in 1904 in between two big moments of codification. The Hague Conferences of 1899 and 1907, which have recently been the object of study of Maartje Abbenhuis and her team in Auckland in New Zealand, the Hague Conferences on International Politics and War, Peace and International Order, two recent works coming out of that school. The takeover of Congo by Belgium in 1908 is another big moment of this period. The Congo Free State ceases to exist and is taken over by the Belgian state as a colony on the basis of a national act of parliament. In a moment where nationalism is quite prominent in Belgium between, let's say, 1900 and 1930, this is all celebrated as an achievement. There's a Nobel Peace Prize for the Institute of International Law, Nobel Peace Prize for former cabinet leader Bernard, who was present at the Hague Conferences, and the fact that Belgium has a colony in an age of empires is seen as an extra sign of certainty for the country's position among the foremost, not only economic, but also political powers in the world. The men who produced the discourse that accompanies this extension are not only university professors. Vincent Genin has described how chairs are established, for instance, at the ULB, the Université Libre de Bruxelles, at the KU Leuven, at the University of Louvain, for Brussels, Nice, for Louvain, Descamps. There also is the practical need of foreign policy to acquire legitimacy through the invocation of legal arguments. The Belgian Foreign Office in the 19th century is not that extensive as one might think. Comparatively, that is not a big surprise. You see the study of Thomas Otte on the Foreign Office mind, on the very restricted administration of the Foreign Office in London in the 19th century. In 1903, the Belgian Foreign Office had 83 persons in its service, and that's already the double of the size of the Foreign Office in 1846. An exam for the purpose of which this course has been taught, was established by royal decree of the 10th of October 1841. This exam was seen as a step towards acquiring the position of embassy secretary. So not, of course, the head of the mission, but the backbone of the diplomatic work. What matters were in the program? That's history, general history and Belgian history, political economy, that is, of course, very much in tune with the intertwining of all sets of knowledge concerning what we would call today international relations, the law of nations, national and foreign public law, the Code Civil, so civil law, the commercial system of the main European states. Remarkably, there was not a requirement of a university degree, but the requirement of the knowledge of Latin and Greek, of the old, what we would call today, dead languages. In 1884, the exam board thought that it could judge that the extracurricular quality of a candidate would be sufficient to bypass the exam. The selection of diplomats was not professionalized or institutionalized in the sense that exam results were seen as an indication in an environment where a diplomatic post was not rewarding in itself and where one thought that social origins, being noble, being wealthy, would give a far more direct qualification to become a diplomat. Hence, this should not be very surprising. Nobility and the court were very much intertwined. Nobility and the Catholic political movement in Belgium were that as well. There was a system of patronage, so people going to their patronus, as in Old Rome, and of recommendation. You needed to know somebody to get it. The process of professionalization is slow. By royal decree of the 1st of August 1858, the exam was limited to those in the possession of a candidate degree, which you can compare to a bachelor, though a candidate usually studied only 2 years in arts and philosophy. So not in law, not in economics, not in science, but arts and philosophy. The minimum age to become a diplomat was 21. In 1887, it was raised to 23. By royal decree of the 30th of July, 1867, the possibility was opened for those in the possession of a degree in civil engineering. 2 people were actually admitted. And in 1888, an extra exam was installed for those who wanted to serve as a consul or who wanted to serve Belgian commercial diplomacy. This was linked as well with the rise in treatment. What is the background of this? The background of this are questions in Parliament on the cost of the diplomatic apparatus and its economic relevance to the Belgian nation as a whole, read to export markets. Recently, Laurence Badel of Paris 1 has published a monograph on European diplomacy from the 19th century to today, where many of the generic questions come into play. My information on the Belgian diplomatic exam stems from a book published in 2014 on the history of the Ministry of Foreign Affairs, where the following exam questions were put forward. For instance, explain the English Revolution of 1688, compare William III and Louis XIV. This is a very historical question. Of course, in the 19th century, it's not that far away as it is today. The background, of course, is that Belgium has a constitutional tradition which appeals in part to its own past, the constitutional charters of Brabant, but also likens Belgium to the British system of parliamentary monarchy, where the representatives of the people, let's say of the wealthy people, at least in 1688, were able to pick their own sovereign, compared to an absolutist French model, which probably also in the time of Napoleon III was still a very good scapegoat or repulsive element. What is the protectionist system? So on trade, which rules are applicable for a blockade? Define perpetual neutrality. How does it differ from voluntary neutrality? This is a classic conceptual question in which I think is highly relevant to see what is the essence in their understanding of diplomats on the law of neutrality. Neutrality law developed in the early modern period and came to signify that the state had the opportunity to choose not to be a party in a conflict between 2 other states. Permanent neutrality, on the contrary, was imposed, and as such could be seen as diminishing the classical definition of sovereignty, namely the possibility to choose. Compare in a table, the executive branch according to the American Constitution with the English Constitution. Give a survey of commercial legislation in Belgium since 1830, translate a German diplomatic speech, analyze a House of Lords speech. 12 points on the exam for history, 10 for the law of nations, 9 for public law, so domestic public law, constitutional law, 8 for civil law, 7 for trade, 6 for consular regulations, 4 for language. Besides the exam for legacy secretary, there was the possibility to enter without passing this test as an attaché. Attaché was again based on patronage and on the generic requirements to be able to enter civil service. Dutch entered in the system in 1922, so only after the First World War and the introduction of universal suffrage for men. In the manuscript of the course, we see regular references to, for instance, the section on history, voir histoire, voir droit civil. So this combination of matters was still present in 1904 when the course notes of Arendt were jotted down by his students. In 1879, the requirements were a bit stricter. Candidates had to have the degree of Doctor of Law, which is the same as Master of Law today, Doctor or Licentiate in Social and Political Science, Engineer, or Army Officer. 41% of the post holders, so the heads of missions, had the degree in law, and recent research from Isabelle Dasque gives a similar figure for France. 39% had the candidate degree in arts and philosophy, so had entered before the introduction of this new rule. 9% had a candidate degree in law, 8% in political science. Who were Arendt's students who could have taken this course in 1904? We see indications here and there. For instance, Henri de Ligne was recruited as an attaché, was from a very well-known noble family. De Ligne is going back to the Ancien Régime. First appointment, 27th of February 1903, without exam, because his father had asked the Minister for Foreign Affairs and because Leopold II, the king, had recommended him. In March 1904, he took the exam. He was a bit too young, but the royal decree gave him a dispensation to take part in the exam at the recommendation of Léon Arendt, the Director General of Political Affairs. On the first page of the Journal de Bruxelles, a Catholic newspaper in November 1905, the results of the diplomatic exam. Monsieur de Royer, le comte Philippe d'Outremont, Charles Papéance de Morcoven et le comte Charles de Liedekerk ont passé samedi au ministère des Affaires étrangères leur examen de secrétaire de légation. Le jury, présidé par monsieur Van Aldegem, président de chambre à la Cour de cassation, se composait de monsieur le baron Beyens, le baron Descamps, le comte Gobier d'Alvela et Arendt, directeur général au ministère des Affaires étrangères. This is very relevant because the president of the jury is a high judge, is a judge in the Court of Cassation. There is an exam on civil law and public laws, domestic legal matters, and the president of this jury is a magistrate. Who else is in the jury? Beyens, big Belgian diplomat, Le Baron Descamps, professor of international law in Leuven, and a senator, later minister for the Catholic Party, Goblet d'Alviela, then from the non-Catholic side in Belgian academics and politics, and Arendt. So who is Arendt? Arendt is a son of Wilhelm Arendt, a German-born professor, born in Speyer, who was recruited by the University of Leuven in 1834. In 1834, a Catholic university founded in Mechelen was transferred to Leuven, where the State University of Leuven, created by William I in 1817, was abolished. The Catholic University returned to the seat of where it had been until the closure by the French in the late 18th century. Arendt was recruited as a professor of archaeology and of literature, and he quickly rose in the Belgian establishment in the sense that he was co-opted in the Royal Academy and that he published a famous book, Essai sur la neutralité de la Belgique, in 1845, a very sound and thorough treatise on the highly complex problem of the definition of the legal status of permanent neutrality. Although he was not trained as a lawyer, Wilhelm Arendt wrote a very important book where he combined both the text of the Treaty of London of 1839, which was not all that elaborate, with practice from the Ancien Regime and the available legal literature at that time. So Arendt, as a classical figure of the first half of the 19th century, took Kluber, Martens, the German authors, Vattel, the relevant Italian authors also on the law of neutrality. Arendt stated in his book that the conditions of the exercise of Belgium's exterior sovereignty were determined by the status of permanent neutrality. This status was imposed by the great powers and created limits. However, one of the advantages, see the image that I projected on Baron Lambermont, was that Belgium could trade with everybody and could conclude commercial conventions. Especially in a country at the forefront of industrialization on the continent, this was a major échappatoire to try to sell the excess production of the country. Leopold I in 1840 gave a famous speech at the end of the Orient crisis, stating that Belgian neutrality would be loyal, strong, and sincere. What was loyal, strong, and sincere? Probably the contents of Wilhelm Arendt's treatise. Léon Arendt, born 2 years before l'essai sur la neutralité de la Belgique, Léon Arendt is described in many works on Belgian diplomatic history, such as that of Horst Vlademacher, who wrote a very impressive work in 1971 on Belgian neutrality as a problem of European policy, or of Daniel Thomas, who produced an equally intriguing synthesis in 1983. The most recent standard work on Belgian foreign policy by Rick Golzat describes Léon Arendt as German-friendly and anti-French. Léon Arendt took a degree in law and in political and administrative science in Leuven. He entered in the ministry at the age of 27 as attaché, so without the exam normally, but passed on to make a superb career. He first worked for the Nobility Council, still attached to the Ministry of Foreign Affairs, where he published the historical regulations and practice concerning noble titles in Belgium. In 1869, he rose to the rank of Director General of Political Affairs, where he succeeded Baron Lambermont, the famous diplomat of Leopold II. In 1907, he was appointed by the king by royal decree as a judge, as well as a member of the Permanent Court of Arbitration. So Permanent Court of Arbitration is created in 1899, is basically a list where parties can choose and pick arbiters to settle their differences amicably. Arendt published part of his production in the public sphere, in the Revue Catholique, the Revue Générale. It's quite clear that he's from a Catholic background. He published an essay on les petits États dans la situation présente de l'Europe, but the main source of his work is in the archives of the Ministry of Foreign Affairs. I've had the pleasure to go through a lot of his notes in what is called the Classement B, so the thematic classification of the Ministry of Foreign Affairs on neutrality, defense, and independence. Many, many notes on legal questions are signed Léon Arendt, which makes him, of course, the ideal gatekeeper for the recruitment of new diplomats. Who is in and who is out in his handwritten course? If we check the text in the transcription, we find very few references to big names of doctrine. Edouard Descamps, on the right-hand side of the slides, is in there. Alphonse Rivier, famous Swiss and Belgian later lawyer. Alexandre Mérignac, French professor in Toulouse. But then most historical personages or figures pop up, like Madame de Stael, Grotius, John Cabot. There is no reference to Lassa Oppenheim, who worked around this time, famous positivist author of international law. No reference to Travers Swiss. No reference to Louis Renault, to Fyodor von Martens, to Ernest Thijs, not to Roland Jacquemins, to the other big figures of the Institut de Droit International, and even not to Emer de Vattel, whom Arendt cites from time to time in his own manuscript advices for policymakers in the Ministry of Foreign Affairs. how did I tackle the document? The document is transcribed as such. At the start of the document, Arendt mentions that the first part was taken down by a not all too talented student. Jusqu'à la page 82, Loi de la guerre, ce cours a été copié sur révision préalable sur un cahier déjà ancien d'un élève peu rigoureux. Tous les fautes, des vieilleries, des phrases incorrectes. La suite elle-même n'a subi aucune correction, mais a été donnée à mes chers élèves. Le 3 septembre 1904, tiré à 9 exemplaires. In this situation, it would be preposterous to start correcting. Where possible, there was a sick inserted in the transcription, meaning that this is probably not correct, but it is written as such, or a question mark when something was not readable. Those instances are, however, quite limited. One should try to envisage a situation in which Léon Arendt found himself while teaching on the law of nations. This is a synthesis of 175 pages for a subject where books were abundant, where the first journals, such as the Revue de droit international et de législation comparée, l'annuaire de l'Institut de droit international, la Revue générale de droit international public, the books of the people I summarized on the previous slide, were already easy to find and probably present in the library of the Ministry of Foreign Affairs, where the people who took the exam could always go for further research. The core of his course was that he needed to explain why international law had changed, had become much more technical and institutionalized in his own lifetime. Arendt is born in the 1840s and lives through the transformation of international law. Secondly, how people aspiring to be prominent Belgian diplomats needed to adopt official discourse and frame the homogeneity or the identity between Belgian interests and the main principles of international law. And thirdly, implicitly, he needed to write a bit of contemporary history. Why the references to doctrine are relatively scarce, but the references to the state practice of his own time was abundant. The structure of the treatise is as follows. The introduction, which I will address briefly, counts 7 pages, but the 7 pages, of course, are hugely important. Why? The doctrinal tradition in international law is such that you try to unify the 2 big chapters of the life of states. Think, of course, just the Rebelli ac Pacis Libri Tres, le droit de la guerre et de la paix. Think of Vattel, book 1 and 2, the state considering itself, relations between states. On the other hand, book 3 and 4, and how to get out of it. Part 1, political relations between nations, is slightly shorter than part 2, conflicts between nations. 15 pages are devoted to the state, 20 to territory, 15 to the essential rights of states, only 13 to relations between states, 6 to conventions between states. The second part devotes 55 pages to war, and 25 to neutrality, and 18 to something relatively new, judicial dispute settlements. If we put this in a Wordle, this is the result we get. For the first part, the word état in plural is used a lot. Souveraineté is, of course, very prevalent. For the second part, guerre and neutralité. In the introduction, Arendt starts with a small pedigree of the law of nations. Les nations, entre elles, sont dans la situation où se trouvent les hommes dans les sociétés primitives. So, nations between them are in a kind of state of nature. Où les pouvoirs publics ne sont pas encore organisés. Where there is no common public law organization. Il n'y a pas un pouvoir supérieur qui leur dicte des lois, qui juge leurs différends et qui les contraigne à se conformer à ces jugements. This is what we call the classical domestic analogy, which we still use to explain how international law differs in its theoretical structure from commercial law, labor law, criminal law, and the other branches of domestic law. However, Arendt frames the march of history as a tale of progress, the progress of the Christian law of nations. Here we see that Arendt's Catholic background, I think, comes to the surface. He evaluates positively the role of the Pope, of the Crusades, qui provoquèrent les associations des princes chrétiens, judgments that would be quite different today with what we know on post-colonial scholarship and also the Arab tradition of chronicles and contemporary sources. Roman law and political equality are associated here with the Middle Ages. So Arendt clearly does not choose for the early modern period, for the Reformation, for Enlightenment, but for the Middle Ages as a root of a tradition of justice and law. From the 16th century on, he sees a qualitative difference in the sense that relations between states become more intense. Le besoin des peuples de se liguer contre les idées révolutionnaires ou contre les tendances dominatrices de Napoléon. Aha! So, intenser relations in the early modern period mean just that they have been preparing to reject the French Revolution and reject the French claim to dominance in Europe. Koolzaat associates Léon Arendt with the German-friendly diplomat in the opposition between the Reich on the one hand and the French Third Republic, progressive, much more left-wing on the other. At present, in his own lifetime, Arendt thinks that he is living through a unique moment in history where the means of international communication are multiplied, where there is much more trade, and this generates a solidarity in material interests. So irrespective of the political side you belong to, Roland Jacquemas of the Institute is a liberal, Leys is a liberal, Descamps is a Catholic, Arendt is a Catholic, they see in the intensification of what is sometimes called a form of globalization before World War I, they see a kind of guarantee that states will refrain from using violence between them. Peace can be maintained par des moyens préventifs. And the rigors of war, which of course we see now every day with the war in Ukraine, will be softened. By which means? By the existence of neutral states who don't take part in conflicts, by arbitration, so by extrajudicial dispute settlement by arbiters appointed by the parties or chosen from a list, as with the DCA, and by the regulation of the usages of war on land and sea. Another quote from the course is on necessity, the argument used by Germany to invade Belgium later on in 1914 and vehemently rejected by doctrine, among others by Edouard Descamps, contemporary of Arendt. Le grand problème du droit des gens, c'est la nécessité, le fait de se mettre en dehors du droit. What are the sources of law? This is an eternal problem in the historiography of international law and in legal theory making, in the sense that a natural law conception tends to emphasize moral elements like solidarity, justice. Positive law conception has the advantage of relying on sources that are tangible and start from a text that has been agreed explicitly between parties, but on the other hand, there is much more submission to the necessities of policy. The positive sources of law, of international law, of law of nations for Arendt, as it uses the expression law of nations, and we should conform to this, are explicit or tacit, in the sense that usages established between nations can be derived from their behavior, that treaties contain the positive traces of their agreement. Then arrives the word civilized states. As an informed reader knows, the theory of the standard of civilization in the 19th century was invoked as an excuse to justify systems of dominance and exploitation outside of Europe, and also as a standard to measure the degree to which a state as China, Japan, the Ottoman Empire, or the states in Latin America were able to be counted among those who benefited from the advantages of equality and sovereignty, as in the Congress of Europe, the so-called Congress of Europe. Which grand conventions are identified by Arendt's free navigation on the rivers, established at the Congress of Vienna, the 4 declarations issued at the end of the Crimean War with the Treaty of Paris, the Convention de Genève, as he calls it, of 1866, the Acte de la Conférence de Bruxelles of 74, the Berlin Act, and remarkably, the Anti-Slavery Conference in Brussels, which is part of Leopold II's justification of the Congo Free State enterprise. Unsurprisingly, he counts very recent history, the Hague Conference of 1899, as an achievement in positive law. Natural law is revealed by reason. One might say, in the best Thomist Aristotelic tradition, natural law, he says, is indispensable. And this is very remarkable. This is somebody, I think, inspired by religion to make this kind of statement, because the 19th century is often seen as a century where positive law triumphs, natural law declines. Authors like Milos Veets have nuanced that. Natural law remains implicitly present as the bedrock of the writings of positivist analysts of the law of nations. One could also think that the impetus of the Institut de droit international is linked to a preference for justice, which can be linked to natural law. Arendt here states that natural law ought to supplement the insufficiencies of positive law, and that it can be invoked when the practice of nations is contrary to equity. So abusive practice can exist, and he associates this with the raison d'etat, a concept often linked to Richelieu and the French style of diplomacy in the early modern period. But how can we know natural law? By going to doctrine. L'autorité des auteurs, bien que purement morale, it's a purely moral authority, but it exists. And that tradition starts, in his sense, from Grotius. Grotius, not a surprise, is en vogue at that time. He gives as an example the setting up of governmental committees to clarify rights and obligations in times of crisis. With the explicit example of the Comité du Contentieux, which is being examined by our colleague Raphaël Cahen. Comité du Contentieux in France, with senior judges such as Joseph-Marie Portalis, the QCs in Great Britain, the Queen's Counsels who advise the Foreign Office for legal questions. In this sense, he thinks that the accumulation of expertise and the use of expertise by the various foreign ministries has a link with the transnational phenomenon of the Institute of International Law, which has members all over Europe. Another part of his archives mentions a list of books to be ordered. You see here Hall, and the German Hefter, Renault. None of them is mentioned literally in the course, but his personal papers contain traces of his wish list for the bookshop. Another point of the introduction asks the question whether international law is universal. For Arendt, there is such a thing as a European international law. Les peuples d'Europe, ou les États chrétiens d'Amérique d'origine européenne, so North and South America, can constitute a common community accepting the same type of legal arguments. The law of nations starts from the idea that there is a plurality of states who are sovereign and equal, that they have mutual relations and are thus subjected to the same principles. A central concept also exposed many times by Kosciuszko and also in a beautiful article on Bluntschli by Becker-Reuben is that of common judicial or juridical conscience, la conscience. Law has a civilizing effect, but also needs a minimal threshold of common culture to work fully. Une égale façon de comprendre la réalisation pratique du droit international. And here, Arendt echoes the idea that the Ottoman Empire has been admitted to the benefits of the public law of Europe in 1856. We know, of course, that in practice, the Ottoman Empire was only admitted in exchange of modifications of its internal structure. So one can ask the question whether it is an admission as an equal partner. The Congo Free State, of course, for a Belgian lawyer working in the Ministry of Foreign Affairs, ought to be in this list as taking part in the advantages of the law of nations. We will see in the part of intervention that it was, of course, meant to keep foreign looks out of the Congo Free State. Lorimer is cited, this controversial author whose theories have been identified as racist is one of the standard bearers of the standard of civilization theory. Lermer has a class of barbarian and savage peoples. Arendt takes over these terms, demi-barbarie, sauvage, à l'égard des peuples qui ignorent ce droit, la conduite doit être dominée par les principes de morale qui sont la base de leur civilisation. And the only principles that are at the basis of people who are excluded of the first circle are property and the right to life. If it's not possible to work with those principles, il faut se borner à des conventions particulières. This seems very harsh. However, for Arendt, this should be relativized. Le droit international comporte une application à tous les rapports internationaux possibles, bien que, à l'égard de certains peuples, il y ait des précautions particulières à prendre et qu'il ne faille pas s'attendre toujours à une entière réciprocité dans la manière d'envisager le droit. So one should start from the idea that reciprocity is possible, and reciprocity will just not be possible in some marginal cases. Is international law? Our colleague Laurent de Zutter has written an inspiring book, Après la loi, on non-Western legal conceptions. Arendt should be open to his idea in a sense that he states antérieurement à l'action positiviste du législateur et des tribunaux, action positive, sorry, not positiviste, le droit existe comme un ensemble de principes de raison. Law is a product of reason, basé sur la nature de l'homme et accepté par leur consentement commun, based on the nature of man, accepted by their common consent. Quant à la sanction, elle n'est pas essentielle au droit. A sanction is not essential. Il y a des parties du droit interne qui manquent de sanctions. Tel est souvent le droit constitutionnel, telles sont les obligations naturelles qui sont dépourvues d'action en justice. If domestic law knows constitutional custom, constitutional usages where there is no hard sanction, if there is the figure of natural obligations in civil law, why should international law not be called law if its moral basis is not that different? Arendt furthermore adds that sanctions exist, or if undertaken for a just course, can be used to sanction a violation of a commonly accepted norm, a coalition against the dominant power or hegemon, or the verdict of public opinion, which is becoming much more important throughout the 19th century. Think of the presence of newspapers and the circulation of books in his time for an international language, mostly in French. If we go to the first part on nations between them, political relations between nations, which echoes a bit the book of Kluber, an older 19th century classic, we find in chapter 3 on essential rights of states a paragraph on intervention. I take the liberty to switch to this one. Part 1, chapter 1 on the state. I hope I'm still sharing my screen. Invitation. Voilà, it's back. Here is the presentation, and here is the transcription. I had the temerity to put the transcription on full screen, and that made the presentation flip. My apologies. The one is on the state. Then we see the various types of state. Chapter 2 is on territory, the classical, the most classical of all categories. Water, the sea, servitudes, the essential rights of states, the category of rights of states, also the subject of a fascinating article by Milos Vets, still survives in the time of Arendt. The essential rights of states in general followed by words on the slave trade and on intervention. Intervention. is of two kinds. One is intervention in a quarrel between two states. Arendt bluntly states that this is possible. You can intervene in a quarrel between two other states if there is a causa justa, if there is a justa causum. Second, intervention in the internal affairs of another state. In principle, it's forbidden, but it's not in an absolute way, in the sense that Arendt, as a moralist and naturalist international lawyer, thinks that the triomphe du bon droit, the triumph of one's own good right against injustice, can impose itself, which is followed by an enumeration of a couple of cases. The first case is that the treaty explicitly provides for a right of intervention. This can concern a right of protection or the guarantee of a constitution, a succession, or a dynasty. Arendt adds that this was erstwhile very frequent, fréquent jadis. It gives the example of the Treaty of Paris of 1815, which ends the Napoleonic Wars with a perpetual exclusion of the Bonapartes. In Arendt's course, students have to learn by heart that this was only scrapped in 1852 when the four allies renounced this principle in a secret treaty. I think this is not without relevance in the general framework of the difficult relations between French and the Belgian diplomats in the 1850s and the 1860s, and especially with the memory that Arendt tries to construct of the French Revolution and Napoleon himself. Second case, when the institutions of a state violate another state's right or endanger it. He gives them the example of the coalitions against France in the 1790s and 1800s, which he considered to be legitimate. Why? Because they wanted to preserve l'ordre social, social order, and the balance of power. Clearly, again, a demonstration of a more conservative interpretation, as we can find them in the first versions of Georg Friedrich von Matens, professor from Göttingen, famous positivist in his treatise in the late 18th and early 19th century. Third case, when the rights of humanity are being violated, when a government forgets its duties or is powerless to repress excesses. The authority for this case of intervention is les auteurs exigent, doctrine. This is a moral element. Arendt derives it from doctrine, as he announced in his introduction. And if this is a case where the rights of humanity are being violated, the intervention should be collective. Another case, state intervenes on behalf of its own subjects, with, again, a culturally connotated case, La Chine. The Boxer Rising in China, early 20th century, is a well-known case where China gets conditions imposed by the main powers who have extraterritorial jurisdiction, who have embassies in China and want to protect their trade against popular unrest. Arendt even states that this is allowed for the protection of pecuniary interests of intervening states' nationals. That is already enough to go through the sovereignty of another state. What is the threshold? What triggers this intervention? If the state on the receiving end has been so daring as to change its legislation or its administrative organization. Another category is the intervention in the external affairs of a state to conserve the others in the superior interest of humanity. With a long enumeration, probably noted down a bit too briefly by the students, from antiquity over the Middle Ages, the 16th century, Louis XIV, the French Revolution, the Holy Alliance, the intervention in Spain in 1823, the English intervention in Portugal in 1826, the creation of Belgium, the French intervention in Mexico in 1862, and the case of Turkey, where the student cynically noted les puissances européennes n'ont cessé d'intervenir. In this case, the definition of the intérêt supérieur de l'humanité is in the hands of the great powers, and Arendt does not see any problem in the law of nations here. He ends with a small peek towards the United States, in the sense that he refutes that the Monroe Doctrine can count as a principle of the law of nations, but rather as a system of a principle of political conduct. If we go back in his treatise to the description of the nation, which he sees as linked to the state but not identical, it's quite interesting that Arendt is relativist to the identity between the nation and the state. L'État constitue, au point de vue du droit des gens, une personne morale souveraine. The state is a sovereign legal person. Il en est autrement de la nation que l'on oppose souvent à l'État. 1904, we should be in the heyday of the nation state. The nation is not necessarily identical to the state. C'est une conception assez vague. La nation est un ensemble de populations unies entre elles par des liens plus ou moins étroits, venant surtout de la race, de la communauté de mœurs ou de tradition, de la langue, de la religion, du degré semblable de la civilisation, et en tant que conséquence le sentiment de leur nationalité commune, ce qui les pousse à se grouper pour se constituer en État homogène. Cette conception est de date relativement récente. So, uniting people around the same language, a tradition, or a conformity of usage is something new. On peut la faire remonter aux proclamations de la Révolution française, reconnaissant au peuple le droit de disposer de leur destinée politique. The right of self-determination is brought back to the French Revolution. Elle s'est réalisée tout d'abord en Allemagne, dont les États se sont unis sur l'influence des attaques de Napoléon Ier. Napoleon is responsible for German unity. C'est Madame de Staël qui a la première révélé les tendances germaniques à cet égard et qui semble avoir créé le mot nation dans ce sens. Curious interpretation, one could ask where Arendt got it from and why the student decided to take this down. There's also a process of communication between the lecturer and between he, or she, not she in this case, who receives the message. Le congrès de Vienne ne tint aucun compte de cette idée en remaniant la carte de l'Europe. Is this a reproach of Arendt to the Congress of Vienna, or is this more his cynicism towards the idea of the nation state? Cette indifférence à l'égard du sentiment des populations fut peut-être une des causes de la réaction qui s'est produite depuis en faveur du principe de nationalité. La réaction s'est manifestée en 1849 par la tentative d'indépendance de la Hongrie et par la lutte des populations italiennes contre l'Autriche, puis par l'insurrection polonaise de 1863. How should we interpret this passage? Is Arendt critical of the French conception of the nation state? Or is he more reproaching the Congress of Vienna to have suppressed nationalities? And how should we see this from the perspective of somebody of German descent in the Belgian state at the height of its most nationalist phase? Closely linked with Belgian independence and Belgian interest is the chapter within the part on war on neutrality. Colzat, in his book, stated that Belgium under Leopold II, so while Arendt was in office, had a policy of strict abstention and isolationism. Horst Lademacher, a German scholar, stated that this was a pures Abhängigkeitsverhältnis vom guten Willen der Großmächte. Arendt devotes 25 pages to this topic, starting with a historical panorama. Again, this is an historically constructed vision meant to defend the interests of the Belgian state, but implicitly this means classifying events and attaching a judgment of value to them. He makes an inventory of recent state practice, as we can also see in the recent monograph of Gabriela Frey on Great Britain's international law and the evolution of maritime strategic thought. The same conflicts are taken into account by Arendt. The Austro-Prussian War of 1866, the Franco-Prussian War of 1870, the war on Cuba of 1898. It cannot escape the Hague Conventions, the Institute of International Law, the Declaration of Brussels. Arendt sees three types of neutrality: voluntary neutrality, partial neutrality, and perpetual. Voluntary or classical neutrality, as I explained, is a decision of a state not to take part in a conflict between others. Arendt thinks that it should not be declared, that it ought to be presumed. So any state not having explicitly taken part in a conflict is under the obligation to abstain and to behave impartially towards the belligerents. The most developed parts, you might have noticed the presence of the word navire in the wordle on the part on war, instead of maritime neutrality. And my presentation is going down again. Voilà. Move this back. A theme that is recurrent in much of international legal theory, but was awfully important, especially also for diplomats and persons with the responsibility to protect the interests of Belgian individuals abroad, is the behavior of individuals and the general responsibility of the state under the framework of the law of neutrality. Arendt sees a slow evolution towards an indirect obligation to prevent violations. L'État n'est que la réunion des individus. This reminds us of the system in the United Kingdom and the United States, where there is an enactment that makes it criminal to enlist for a party in a war while the state itself is neutral. This starts to be presumed. This is an evolution. This is a recent phenomenon. Arendt bases himself on the positive law sources, and I think that is quite typical for the ambivalent outlook of the whole course, namely declarations of neutrality produced during the recent conflicts. If we go to the standard work of Jessup and Deek, we find a nice inventory of the proclamations, for instance, by the Prussians during the Crimean War, the declarations issued by Belgium at this occasion to implore individuals not to trade with the Russians while the war is going on. However, individuals cannot be held responsible if there is no solid basis in positive law. He gives the example in 1898 of American complaints against Belgium during their conflict with Spain. L'Amérique eut une mauvaise grâce de se plaindre de ce fait, elle qui avait pendant la guerre de 1870 livré aux Français de grandes quantités d'armes. This is one of the instances where Arendt shows how private interest or the interest of the Belgian state can intervene and prepare the mind of the diplomats who will have to convey this discourse afterwards. The enlistment acts come back when we treat the Alabama case, which is of course well known. Defending neutrality, going back to the treatise of his father, is an obligation. A neutral state has the obligation to be credibly neutral and cannot let violations of its neutrality by one belligerent pass. There is an obligation to complain if your neutrality has been violated by one of the parties. If you don't do this, you're implicitly granting an advantage to this one against the others. One should insist on reparation. The armed nature of neutrality does, however, not go further than defending sa neutralité les armes à la main. Ça n'est pas sortir de sa neutralité. How should these generic obligations be interpreted in the framework of perpetual neutrality? A perpetual neutrality is a pledge never to wage offensive war. This goes together with a guarantee, because it is a big concession towards the great powers. The great powers consent that they will come to the rescue of the neutralized country if it is attacked. Arendt thinks that this implies two types of consent, by the guarantors, but also by the neutralized state. Permanent neutrality restricts the external sovereignty of the neutralized state. And in this sense, Arendt differs from the writings of Ernest Nys, who tries to reason this away and posits the liberty as a state of the neutralized state as the standard situation and the restriction as the exception. Why is this restriction accepted? The restriction is accepted by the neutralized state because the guarantors will intervene against an aggressor. In explaining the origins of neutralization, Arendt goes back into history and into politics. Neutralization is created to safeguard small states, to create barriers, des états tampons, citing Thiers, a famous French politician across many regimes in the 19th century, and applies two conditions. First of all, it's a state of minime importance, not very important. Secondly, the state has terminé son évolution, which can also be seen as a theological aspect. He gives the example of Greece refusing neutrality in 1863, the example of Piemonte refusing neutrality before the whole of Italy was unified under the leadership of Piemonte. What should a neutralized state do in a more strict way compared to a normally voluntary neutral state? The abstention, for instance, should be strict. Belgium could not guarantee the neutrality of Luxembourg in 1867. In 1885, for Congo, Arendt thinks that the puissance signataires, so the parties who signed the final act of Berlin, had promised to respect the neutrality of the Congo Free State, but not à la faire respecter. So the guarantee offered to the Congo Free State would have been smaller than that offered to Belgium. Would that mean that conversely the obligations of the Congo Free State would be less extensive than those of Belgium? Asking the question is probably answering it from his perspective. No alliance is allowed, states Arendt, either offensive or defensive. This is a classical point of contention. Could, for instance, Belgium conclude a defensive alliance with the Netherlands? That is highly difficult because if Belgium allies itself in a defensive alliance with the Netherlands, it promises to help the Netherlands if aggressed. Belgium gets caught in a war where it is normally alien to and has not really a good interest to be caught in. Même pas pour maintenir une paix générale. A permanently neutralized state cannot ally itself even with all the other powers of Europe to maintain a general peace, because that inevitably means that it will get caught in a war. Colonies, protectorates, are possible for a permanently neutralized state, writes Arendt, si l'État neutre prend les mesures pour étendre sa neutralité à ses nouvelles positions. The automatic question one could ask is, if Belgium, for instance, acquires a colony, can this extension of neutrality be done unilaterally? Because permanent neutrality is a reciprocal relationship, which requires the consent of the neutralized state, but also of the guarantors. If you guarantee my independence and I enlarge my territory, that enlarges also your obligation. Would the guarantors need to give their consent? Arendt does not answer the question. The customs union, a classical example of something that permanently neutralized Belgium could not do with France, is also mentioned. However, Arendt cites as a counterexample that Luxembourg is still part of the Zollverein, although Luxembourg was neutralized in 1876. He sees no problem with a personal union, as Luxembourg continued in a personal union with the Netherlands until 1890. Treaties can be contracted, but of course, no reciprocal alliances. One can obtain a promise from a third party to guarantee neutrality, but one cannot do the same thing in the other way. There is a positive duty to defend oneself, as highlighted by his father at the demand of Leopold I. Outside of this list, there is an indépendance complète, but one might conclude that the list is already quite elaborate. Safeguarding neutrality means that one needs to have neutrality respected and defended d'office, even against the neutralized state's own will. This brings Arendt to the bizarre case of August 1870, where Britain and France and Britain and Prussia concluded a convention. Britain, France, and Prussia were all three guarantors of Belgian permanent neutrality, but France and Prussia entered a war. Neutralized states outside of Belgium, Switzerland, de facto before 1814, as Arendt saw it, sans qu'il eût garantie. Krakow did not live very long. Luxembourg has a collective guarantee, but remains in the Zollverein. Its fortifications have been destroyed, cannot have the status of armed neutrality, is in fact de facto désarmé. The Ionian Islands, shortly, but part of the Greek territory. The Congo River, une neutralité purement facultative, une sécurité au commerce et à l'industrie pour favoriser le développement de la civilisation. For Belgium, for a more elaborate discussion, he refers to the course of Histoire et Droit Public, so two of the other matters taught at the exam, treated by his contemporary, who recites twice in his course, Édouard Descamps, in his big book, La neutralité de la Belgique. I refer to my chapter on Descamps in the collective book edited by Sean Morris. So this is only a part of an elaborate, fascinating, and really detailed course given for a practical purpose with only very few authors cited, but with an illustration of what the Foreign Office mind of somebody from Arendt's own contextual background might look like. He's part of the elite of the Belgian state, part of the Catholic majority which rules sans partage between 1885 and 1914. So many themes are treated, so many themes can be reinterpreted from our contemporary terms of interpretation, like the question of imperialism, colonialism, and domination. But we should also take into account that this man lives in his own age, and that as somebody from German descent, the security question in Europe in an era of imperial rivalry pops up here and there. In the small examples I've shown, it's clear that he aims at the French Revolution, at Napoleon, at attempts of dominating the continent. Much more is to be done, I think, and this is why I decided to give this source to all other potentially interested scientists, wherever they might be located. This is fully transcribed and can be copied and pasted in Word or in TXT format or any other format that one might prefer. This project is associated with DOI on the Open Science Foundation's website. There currently is an accidental labeling of this transcription as spam, but I'm sure that they will resolve this soon. In the meanwhile, it is possible to consult the transcription on the site of our research group. This is presented as 4 wiki pages, with, of course, the most consistent one on les conflits entre les nations. Classical big corpus text analysis tools will not help you towards finding the intellectual background of what he's writing. That requires a content analysis and a comparison with the classical sources of doctrine, journals, books. However, it is possible to trace words, specific wording of things, to trace specific conflicts, like the Crimean War, like the Franco-Prussian War, to see how many conflicts of the early modern period survive. It's substantially less, of course, than in the treatises in the start of the 19th century. But although Léon Arendt tries to distinguish modern international law and the old droit des gens, there are still many instances where the intellectual influence can be felt, especially when he discusses the Middle Ages or the status of the papacy or the influence of natural law. His intellectual frame of reference clearly goes further than a mere state practice. I hope that this is some kind of introduction to a highly complex type of communication between a restricted elitist audience. One should imagine that most people in the classroom, maybe 4, 5, 6, would it really have been 9, will have been attentive followers of international events in their lifetime, might have spent the time as attaché in the ministry, so we're presumed to be well aware of many things that have been explained. The systematic structure of war and peace, the treatment of the rights of the international community against violators of international norms tend to converge in defending the interests of Belgium as a state. Some stark statements can be used to liken him to most recent analysis of the problems of colonialism and imperialism. But I think if we really do an impartial close reading of the text, it might be possible to come to more nuanced results. I hope that this can serve others or can serve as an element of comparison with other courses, such as that of Louis Renaud, who taught in French, also in the same language to the French diplomats, and hopefully one day in comparative perspective also with what has been available to Prussian diplomats or what has circulated in the diplomatic service of cultures outside of Europe, a theme which is now also very thoroughly researched. And thank you for your attention. I will stop the recording. I'm looking forward, of course, to your questions.